Welcome to our CFP Exam Prep discussion on ERISA protection and retirement plan asset security. Today, we're diving deep into a crucial aspect that frequently appears on the CFP exam. Understanding ERISA protection is essential because it directly impacts how retirement assets are safeguarded from creditors and bankruptcy proceedings. Let's break down ERISA protection into its core components. The Employee Retirement Income Security Act of 1974 provides unlimited protection for qualified retirement plans. These include 401k plans, pension plans, and other employer-sponsored retirement accounts. A key point to remember is that ERISA protection is automatic and absolute. There's no dollar limit on the protection, and you don't need to take any special actions to receive this coverage. Many test takers make a critical mistake by confusing ERISA protection with other forms of creditor protection. For example, IRA protection is determined by state law and bankruptcy code, not ERISA. Traditional and Roth IRAs are protected up to $1,512,350 in bankruptcy under federal law, adjusted periodically for inflation. This is a common exam question that trips up candidates. Here's a practical example that often appears on the exam. Consider a scenario where a business owner has $2 million in a 401k and faces bankruptcy due to business debts. The entire $2 million is protected under ERISA regardless of the bankruptcy filing. However, if that same business owner had rolled over the 401k to an IRA before declaring bankruptcy, they might lose protection for amounts exceeding the federal bankruptcy limit. Another crucial concept is the anti-alienation provision of ERISA. This provision prevents retirement plan participants from assigning or alienating their benefits. The only exceptions are qualified domestic relations orders and IRS tax levies. Test questions often explore these exceptions, so remember them well. A common misconception that appears in exam questions involves inherited retirement accounts. ERISA protection does not extend to inherited accounts, even if the original account was ERISA protected. This distinction has been reinforced by Supreme Court decisions and is frequently tested. Let's address some technical details that often appear in exam questions. ERISA protection applies while funds remain in the qualified plan. Once distributed, the protection generally ceases. However, if funds are directly rolled over from one qualified plan to another, the protection continues uninterrupted. This is why understanding the timing and method of retirement plan distributions is crucial for the exam. When studying for this topic, focus on the specific types of accounts that receive ERISA protection. Remember that simple IRAs and SEP IRAs, despite being employer-sponsored, do not receive ERISA protection unless they're part of a formal employer plan with other employees. Solo 401k plans, however, do receive ERISA protection even with just one participant. The exam may present scenarios testing your understanding of creditor claims against retirement assets. Remember that even in cases of fraud or criminal activities, ERISA-protected accounts generally remain secure from creditors. The only significant exceptions are government claims for criminal restitution and certain domestic relations orders. To solidify your understanding for the exam, remember this framework. ERISA protection is absolute, automatic, and applies to qualified plans. It continues until distribution, survives bankruptcy, and has very limited exceptions. Know the distinction between ERISA and non-ERISA accounts, and always consider the timing of distributions when analyzing creditor protection scenarios.